So this has got a lot to do with those resolutions and so forth that I've been talking about. To do with, you see, I'm pretty sure now that the Petitions Committee have spun this entire right to reject or right to rebuff these online petitions based on a one-liner, which is in one of the dialogues for the resolutions, which says that, petitions, if they're fit, if they're fit. But what it actually meant is that, you see here, look, we've got this who could sign their names in Cornish village in 1642? In Tremaine, all men made their protestation oath with their mouths and their hands. The curate and 8 others signed. The remaining 28 subscribed with letters or marks, including constables, churchwardens, and overseers. So what this research group have found is that, many people actually went to a lawyer, like you and me go to a lawyer now to get legal help or legal advice if you need it. These people actually went just to get someone who could write, who could read, who could actually write it. In fact, the lawyer was merely, so to say, the scribe or the secretary. Many times they went to a member of the clergy, because they also had church courts, remember, but a priest or a clergy who had learnt to read and write. So these people weren't even literate, many of them. They just put their mark on, but they could talk, they could speak English, and if they wanted to make a statement or a plea or a complaint, they could voice it, obviously, in their native language with their native peers, but many of them couldn't even write. And I'm quite certain that is what the wording means, if they're fit to be received or whatever. Some of these people couldn't write properly. And unfortunately, the thing is now, well, we have grammar. Everyone is required to be educated in the language of English. And if you have got like a qualification in the English language, A, B, or C, not even in law, then, how can you not, not read and write? This is the thing. Now, the thing is, now that everyone can read and write, lawyers aren't there to write for us. They're there to make representations, but most of the representations in court are merely like, black belt barrister, having the skill of being able to argue a case and know valid points to argue on. But mainly solicitors and lawyers now are valued for their knowledge of procedure, their knowledge of court procedure, how to submit. You see, for example, me, it's you can go on the small claims court online and anyone could submit a case, but you've got to have the courage to go through with it. You've got to have the confidence. A lot of times I've been in court, answering to court, I found that, I've read procedure rules and I kind of understand them somewhat, but I'm being misled, tricked, deceived, persuaded out of my plea, or one room's full, or all manner of, it doesn't, unless it's almost like a clique, and whenever you speak, you don't really seem to get a proper chance to speak, and even when you say things valid, they just disregard them. It's a sad affair. It almost feels like I've never, it's meant to be, all proper procedure and come in and sit down, but I've never been, as an honest, person growing up, who's brought up among humans, among people, among society, to go about life in a altruistic, honest manner, as we would in a civilized world. I've never felt so conned in courts and cheated, and injustice at the system, at the process, and the thing is, reading law and studying law, I learn more and more, and I usually find out that I'm right with my initial hunches. Some things I read that I'm wrong or I misunderstood it, but I usually did understand its underlying principle, and sometimes I might have misunderstood what it was applying to. But as it turns out, as I was reading it, there was a principle behind it, and then as it turns out, that principle that I understood when I was reading it actually does apply to the things that I thought it did, just because it is a legal principle in effect in multiple places or in multiple acts and procedures, because, it's logical, even if, this is the whole thing, the whole point in law, although, sometimes, it matters on words, but I'm calling them out on words now, like in the Petition of Right, in 3 of the Petition of Right, judged by the judgment of his peers, or by, the law of the land. But, in some versions, someone's put the wrong word in and put and by the law of the land. And that's really important, because that one word, 2-letter word, the single 2-letter word is the only reason why Extinction Rebellion have been getting acquitted by 50% of their cases by these juries, when they've just been acquitting them on their own feelings or opinion, regardless of the law, like in Ian Bray case. And then, now we've got these issues with some judges telling jurors that they've got to decide a certain way, or they're not allowed to decide based on their own opinion when they are institute law. So when it comes down to analysing exact words and letters, how it's worded, I feel that I'm competent at doing that as well as the general thing. Sometimes I make it complicated. For example, when we're dealing with this Justice of the Peace Act 1997 and the Courts Act 2003, with this principle I found in there that statutory instruments are subject to annulment and the pursuance of a resolution by our Houses of Parliament. Well, that means that you're making an appeal for a resolution, and subject to that appeal, the instrument in question. But also, it does say in the Act, it mentions to orders by the Queen. Councils can make an order for a road, how a road is managed, a road traffic regulation. And if that order expires or is needed to be long-term or something like that, and the order doesn't cover it, then they make a statutory instrument. And that is more of a permanent secondary legislation, but it can have the same effect as an order. So an order can be for the same thing as an instrument. Now, we know that government makes instruments and people within the government, but orders are made by justices of the peace and persons with authority, but they can be for the same thing as instruments. Another thing is that they use instruments as well to make orders. They actually use an instrument to make an order because it's got rules for making orders in it. And you can actually get, you can seek a resolution for an order as much as an instrument or even an act of law. And the basis for that is that when you pursue a resolution for it, well, it says the instrument is subject to annulment. I've got a really good model for this. I've got a very, very, very good model that really, really exemplifies this. And again, it's the Town and Country Planning Act. It's such an amazing instrument, that act, for petitioning, because the majority of things you do for petitioning concerns the placing of notices, using signs in public, models, things like that, and through the use of the enactment. So the Town and Country Planning Act 2007 is such a very, 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 it's probably the primary, it's the primary statutory instrument that you would need to either use or touch or know about if you are going to engage in petitioning. And the thing is, the point of the instrument is to protect you from orders, protect you from the council and justices of the peace making orders against you, or the police making charges against you. Particularly when, the 1990 Act in word and letter defines what an advertisement is, and, defacement, which is through the use of it, and makes you not liable for that. And it definitely describes it. It basically disqualifies it from being allowed to be described as damage in the Criminal Damage Act. So it's describing, it's dequalifying it from you've been touched by the Criminal Damage Act, which is why Angela Ditchfield's case is so important, and the Max Hill, the Chief Crown Prosecutor, completely ignoring that act and instrument. Now, but the thing with that instrument is this. So, if you had an order made against you, let's say for defacement or, unlawfully placing a notice in public, it's political, but if you were wrongly charged, you would want to get that order annulled or overturned or appealed to it. But if you've already got a case with either of Houses of Parliament or pursuing one, then surely you're appealing it. So the appeal, even if you appeal to a Crown Court from a Magistrates Court, it annuls the Magistrates Court order. Or if the council fine you, then it annuls the fine from the council. Now, the thing is, you say, in that Justice of Peace Act 1997, it's saying that, a statutory instrument is subject to annulment on pursuance of a resolution of either House of Parliament. Well, the ironic thing is this. What happens if you said, all right, then, I'm going to seek the entire statutory instrument of the Town and Country Planning Act being annulled because I want a resolution of that statutory instrument from Parliament. So that would annul the instrument, right? That would annul if you got a petition for 100,000 people to resolution and contest the actual Town and Country Planning Act 2007 statutory instrument itself to Parliament, then they're saying it was subject to annulment pursuant of that. So actually, while you're pursuing it, now the thing is, if you had been unlawfully fined or prosecuted through that act, then the fines and prosecutions would be annulled because the instrument of which they used to fine you would be annulled. So there wouldn't be any charges existing to prosecute you through. So, but then you'd thought, well, why would you want to get rid of that act? No, not the act. Sorry, the instrument. Why would you want to annul? Or why would you want to seek a resolution for the Town and Country Planning Act 2007? It's brilliant. We need it. We're using it. We use that for petitioning and it gives us protection. So why would you want to get it annulled? Well, the thing is, it doesn't matter because the thing is, while it's in effect and while it works, we can use it and it gives us protection and stops us getting fined and prosecuted. But if you pursued a resolution for it to get it annulled, then you also won't be able to be prosecuted or fined because the whole instrument will be annulled. Because if the whole instrument is annulled when you're seeking a resolution of it, then it has no effect. So it doesn't matter whether you are using it, because the thing is, the whole purpose of it really is to regulate and control placing of notices. And give you legal right to do it. So while it's in effect and you use it, it's great because that's what you're using for your use of the 1688 Bill of Rights, and that's what acknowledges what you're doing, and people can recognise what you're doing, right? But so that's good. You want to use it, but even if you contested that statutory instrument or wanted a resolution from it to Parliament, then by it being annulled, then there won't be any charges for them to bring against you through it, using the instrument, because it won't exist with it, because you're seeking a resolution from it and it's been annulled, because it is an instrument. So can you see what I mean? It doesn't matter, all those orders that they would make through it against you, right, which are illegal anyway, by the way, if you're using Class F and the 1688 Bill of Rights, if you seek to pursue a resolution of that instrument, then the whole instrument wouldn't have an effect, and there wouldn't be any charges for defacement or placement of notices because there are no regulations for it if that instrument doesn't exist. Do you see what I mean? So that's why, kind of like, you see, the thing with the instrument is this, right? So let's say a judge makes an order. If a judge making an order is a whistle like this, right? So if a judge making an order is a whistle, right, he can still whistle and make an order. But what instrument is he using? But now if he picks up a trumpet, that is an instrument that can be used, but he's still got to blow through it and use the instrument to make a whistle or a sound, make an order, right? The thing is, without any instruments, you can't make any music, but you say, well, I can play, just talk, right? But, without any law and without any acts, there can't be any charges against you and there can't be any prosecutions, because the charges and offences only exist with legislation and instruments. That's the thing, But you say, well, what happens if there isn't any law? Well, if there isn't any law, you'd have to ask for some law to be made. Use your mouth, create from nothing. You don't actually need an instrument. You can create it with your mouth, This is the thing. I mean, maybe that's not a great example, because without any law or acts, no justice can make any orders. But he might be able to request an order being made to the government, and then he would have an equal right as you do, But anyway, so going back to the point on, this quality of petitions and people not even being able to write their own name and so forth, I'm quite certain that is, what they mean through many of the resolutions, even in the 1800s ones. And I think that back then they were being persecuted and undermined because they couldn't read and write. Now everyone can read and write. We're being persecuted and undermined because they claim we don't know the law, or we haven't got a degree in law. But, the thing is, we can read and write, so you can learn law and understand it. And to be honest, it's not that complicated. And the fact with Parliament is, you're either appealing something or putting in a fresh complaint or grievance, and usually you're taking it to Parliament, to a national level. You might have, they try and they're wanting you to take it to the local council or authority, but you might not get the outcome you want. And we have actually got the right to take things to Parliament, and no matter what committees they've got, or calling things in from the council or judicial reviews or other processes, the process for petitioning the House of Commons over the matter exists, and you've got the right to do it on any subject or matter you want from anywhere in government. And unlike any of the other avenues of complaint, it goes on the weight and volume of signatures you get, the volume of public concern, as well as your facts. In fact, they've made the form so you can't really put much detail of facts. It's all based on whether the public want it to be debated and what they think by sheer numbers and volume. I don't think that the Petitions Committee can reject petitions with their standards, because there is certain procedure for having them read out in Parliament through different standing orders, but the one for the committee is Standing Orders 145A, which I've said, there's nothing about what you can and can't submit. And I don't think that those older resolutions and standing orders are definitely to do with, grammar and punctuation. There's another thing, a lot of things, like I've submitted a petition that I want to challenge the local council on the town centre redevelopment, because, we're objecting to it, and they've fobbed us off, and seeking a resolution from the House of Commons. So, I've put the application number in there and the link to the application on the local council website, which is HM Government, and I say, we want a resolution on this, and I've got a right to collect signatures on it from everyone in England. And there's a legal right of any subject. Now, they likely will reject it. And the thing is, when they reject it, you've got to reword it and then resubmit it and get another 5 signatures. But on some of the guidance that I've found, it says that you can actually challenge them on rejecting it. But when you get into disputes and email, they just fob you off and say, rewrite it and resubmit it. But then you've got to collect 5 signatures again. But if there was nothing wrong with it and it didn't need changing, then they're meant to actually publish it. And I've argued with them multiple times to publish petitions that I've submitted, and there's nothing wrong with them, and they haven't done. And this is why I'm complaining to the Judicial Conduct Investigations Office about that committee, because that committee is under the jurisdiction of the Judicial Conduct Investigations Office through the Constitutional Reform Act 2005, Section 5, representation to the House of Commons, which includes the Petitions Committee, and they are a authority with powers in, Standing Orders 145A3. They're given powers, and, the committee has a chairman, which, is synonymous. All chairmen are synonymous with Justice of the Peace or chairman of a commission of that committee. Powers. So, and they're unlawfully rejecting petitions. There's no legal basis for it. And anything to do with, standards is, I can guarantee you, down to, grammar and punctuation. And if it's nothing to do with Parliament, if it's something silly, well, what about Monster Raven Looney Party and their, policies that they put out? The thing is, if it's something from a local council which has already been entered and processed and even actioned, how can it be a illegitimate subject? It's an existing case. It would almost be like if you appealed to a Crown Court from a magistrate's court a case, and then they said, "Oh, this case is invalid, a load of tosh, a load of rubbish." Well, how can it be when it's been heard in the court? The thing with the Petitions Committee is there's a lot of things that they're claiming they can't hear, or matters they can't touch upon and stuff like that, or even that your things are, libelous or false or whatever. But there's a lot of things that you're submitting to them for a resolution, which are things that are officially already been through another area of government. So how can you reject it? Because it's like a official, legitimate thing. So a resolution on this, I want to collect signatures on it from all England through a resolution of Parliament, because I've got the right to any subject I choose without being held to any commitment. So it's impossible for that Petitions Committee to reject a petition of a planning application from a local council that is registered, logged, and has been actioned, that you want a resolution on, because it's a thing that is being already, what you say, legitimised. It's not like, a Monster Raven Looney Party clause that, the government don't deal with headless chickens or whatever, or, a new flavour of sausages to be invented. Things like that. Fair enough, if it's absolutely nothing to do with any government department or anything that the government is responsible for, fair enough. But a lot of these things clearly and evidently are. Even if, look at Boris Johnson, for example, when he's doing promo, when he was Prime Minister, he was doing a lot of PR stuff, pulling pints or, shearing a sheep and something like that. It's something that he did. So, even if you wanted to be silly, you don't want the Prime Minister to, jump out of an aeroplane with a parachute or something like that, or onto a, large trampoline that's, 100 metres square, see if you can hit the target, a stunt, for a PR, then, you could petition them to do it. I'm a celebrity, get me out of here. We want the Prime Minister to do it for PR. Or just for entertainment. Why not? You've elected him to the Prime Minister. He likes pulling pints and shearing sheep for PR stunts. So, that's silly. But, you can have it. You can ask him, the country can say, we want to see him do it, just for publicity. We want to see Boris Johnson jump out of a plane with a parachute. This is the thing. He likes doing stunts when it's, when he chooses what stunts they are, but, he chooses what stunts he wants. This is the thing. So, and I'm pretty sure that, going back to the, whether petitions are fit or not and how far they should go, I think that's to do with the Tumultuous Petitioning Act and the other bodies that were involved in the process, which is all now being revealed by this. By this hashtag, the power of petitioning or power of petitioning. All this research now has been transcribing petitions, because a lot of them are very, very hard to read unless you're an expert in handwriting, because they're all in 1600s handwriting, which is quite difficult to read. I can't read a lot of it. Some of them were transcribed. In 2019, I obtained some specimens and I was studying it because I needed to get evidence for my case in 2019, which was sort of mid-2019, and I had obtained some petitions and pursued it to the National Archives. I'd been, sniffing around and asking questions about it, and I wanted to try and get a lot of these petitions together to find out what was going on with it all. And so, at the same time, when I really needed that information and really needed that knowledge, and I had to defend that court case, and I got prosecuted and subsequently, sent to community service. But then then we had the pandemic and lockdown and so forth, and for a year or two or whatever, and then subsequently we've slowly come out of that, and then time's flown. Is actually, extinction while I was sort of, sorting out the consequences of, my case, and then, there's Extinction Rebellion, started kicking off with their protests, getting a bit of attention, and then, all that distracted everyone. But then was a pandemic and lockdown. A lot of people, a lot of things happened, and then we slowly came out of that. We were coming out of the pandemic, and then we went straight into, we slowly kind of gone into this whole stop ULEZ thing now, and then this 20-mile-an-hour speed limits. And the thing is, it's quite ironic, really, because at the time of mid-2019, when I really, really needed all this petition data that these research groups have now put together through the lockdown, now we've got it all. We've got all this data. And also, I needed signatures, for the campaign against illegal road signage. And, now, Stop ULEZ are, proving there's legal road signage, but they're also opposing all the cameras. And then you've got in Wales, the 20-mile-an-hour speed limit petitions, and the road signage with that. They've got over 400,000 signatures, and they're supposed to be allowed a referendum on it, which the government in Wales are denying them, and the First Minister's stepping down, which they're allowed it. And then you're allowed to amalgamate petitions on similar or the same matters which are relevant. Well, if they're going to have a referendum on the 20-mile-an-hour speed limits, they might as well have questions on that referendum about the 50-mile-an-hour speed limits and about speed camera vans in general, and on the road signage, and possibly even for investigation into it. So, now there's all those 400,000 signatures, which is, equal 4 times more than 5% of all Wales. I've actually submitted a petition. I've lodged it with them. It's officially submitted, although they're trying to reject that as well. When I have a legal right to, I called for the referendum. I said, look, right, we want a referendum on Wales now, on the 20-mile-an-hour speed limits, because we've got 400,000 signatures, which is what you do. You called for it and you request them to be amalgamated, and then you can say, well, it's the same subject, so I'm going to propose some questions that can be on this, referendum, or questions that are in and around the same subject, which I was entitled to do. So that solves all the problem of the signatures. For my petition as well, and my whole investigation, to get a resolution for my petition, because it can be amalgamated to, should be amalgamated to it, really. That really solves the whole thing. Now, the only problem is, at the moment, I've still got, I've had some of my order discharged because I've been ill. But a lot of people, when they had probation service was locked down for that, for the pandemic, probation was closed anyway. But where I'm at now is, I still want to prove the right to petition immunity and so forth. I've got complaint with the Judicial Conduct Investigations Office, but there are other people now facing charges when they're doing petitioning. But the thing is, a lot of the protesting and the actions are happening because of these rejected petitions, and because the government and Parliament aren't giving them the vote or acting on them, particularly in local government. And then people complain up to central government, mainly because of this Magna Carta basis, which is that, you can get a lawyer, you can argue something on point of law, right, and rules and regulations, but in British law, you have the rule of law, but you've also got the jury that can decide to not actually bother acknowledging the law, or vote to disregard the law. And that principle actually applies to planning applications in the council, because it's still, well, they're wanting to deprive us of our effects and public amenities and the look and style of the village and so forth. And that can be decided on point of law or on judgment of your peers. Well, who decides whether you have judgment or peers or not? Well, it depends if you go and ask them for the judgment, for the opinion or not. Well, you've got the right to submit petitions for opinion and also petition for a local referendum, which in the Local Government Acts, you can have one if you equal 5% of an electorate. But the thing is, with small planning applications or just house builds in local areas, which really impact traffic and noise and people, usually they're only, it's only relevant to that ward, to that village. Now, wards are established in law, electorate wards are established, and usually, they might have about 3,000 or 4,000 people. So, 5% of these is usually around 600 or 700. And the thing is, they've got a value, when you have in a referendum, it says that, the price, the value of it, the costs are broken down by ward. And each ward is 800, not allowed to be more than around £800. So if it was a planning application for a local area which didn't really concern anyone else, if you go to a village and collect 600 signatures, then that's 5% of the whole electorate. Why ain't the council giving you a vote on it, or a little referendum on it, when it only costs £800? When the applicant might be spending hundreds of thousands on getting plans drawn and doing all this or that, but he's only doing it because he's got money, because he's throwing money around. But he's throwing his money around and it's affecting the whole area, right? Now, if he's just minding his own business and it doesn't affect the area and nobody's bothered, then, let the councils decide on it. But if it's something where people are like, just a minute, we kind of like the village as it is, or we like this or that, and they want to override the councillors, or they don't think the councillors are making decisions in their interest, then you can do it. And then once people understand they've got this power, then, they should be doing that when there's a whole town centre redevelopment. But the thing is, the council are doing a con in a way, because they're going to everyone and asking them their opinion in the consultation. And then even when people in the consultation who choose to give an opinion and don't choose to remain silent, like in an election, and then even when a majority of people aren't too keen on the idea, the council just do it anyway, which is blasphemous. It is complete and total blasphemy. And this is why people are furious. This is why communities have got crime. This is why, we've got noise. This is why they're having to redo all these cycle lanes. This is why people don't like the look and style of the village being hijacked and taken over by corporate entities that the councils have got interest in. And they say, the government, and tell us we've got to do this or that. Tosh. We've actually been hijacked. We've been hijacked and having our powers conned and cheated from us. And it's true that there are certain criteria you can complain about through standard objections, but that's if you just make an objection as a legal entity, as a person, put an objection in on a legal point or clause. That's an illegal argument, which it should, against the applicant or to the council. If your complaint's not successful, it doesn't have to be decided on point of law. That's the thing, and that's what they don't like in these legal cases with Extinction Rebellion, like Ian Bray and Gregory Perrins. At the moment, the Labour government and the Labour-controlled local councils really are they're a couple of sandwiches short of a Gregory Perrins kit trial. Because people are saying, no, we don't want things. And the council, are a bit like Gregory Perrins. They don't like it. And this is the problem. Well, we've got the right to say, no, we don't like it. But the corporate entities and players and partners and Care, Balfour Beat Me and the rest of it, they've been doing deals with the devil. And they think that they've got us in the process and procedure, but they can't override Magna Carta, what it's founded on, or the right to petition. And really, we have got local referendum available. And look, Drakeford is at the top of Mount Everest. Drakeford now is public enemy number one, because he wanted to get elected in to serve the people, and they've all signed, 400,000 plus people, to say that, they don't like 20-mile speed limits, and they've got 4 times as many people required than, to get a vote on it, and he doesn't want to give them a vote on the referendum, or let them ask or answer any other questions about speed limits, mobile camera vans, or anything else. He just won't do the job. He'd rather stand down. It's either, my way or the highway. Drakeford's like, it's my way or the highway. But what are you elected for? Are you elected to serve the public or not? Well, clearly Drakeford doesn't think that he is. So we've got a problem now, because I actually submitted for, called a referendum on that, and it's been lodged, and I can also have my petition actioned as part of it, and so forth, my legal case, which is, that's already filed with Parliament, and I was supposed to have protection for that anyway, which is, disputed with the Judicial Conduct Investigations Office as well. And then we've also got all these, Stop ULEZ and, Julian Assange and everything else. And really, Julian Assange has got the right. We're petitioning Parliament over Julian Assange as well. We've got a feeling they're going to try to reject those, because, he's got a right to be released pending a resolution from Parliament on the matter, and let people, sign, collect 100,000 signatures on it. I don't see why you should be detained during that process, because it says, the resolution's being pursued, really. If people want to sign it. There's another thing, actually, I've just been reading in the procedures of Parliament, and those resolutions and standing orders and so forth from, 16, 17, 1800s, and it actually says that there are certain rules for reading petitions out in Parliament, and actually, if something is of concern or danger to the public or to a person, ironically, when you've got the right to petition immunity, even if you leave things that are a risk or a danger to the public, you're not liable to be fined or prosecuted in the Town and Country Planning Act 2007 statutory instrument. You're actually exempt from liability, which is immunity through that statutory instrument. But that's just you liable to be being prosecuted. It doesn't mean that, there shouldn't be something done about any danger, damage or harm, but it's just about being liable for criminal prosecution, defacement and so forth. Assange is in, he's having justice to none we will deny, to none we will delay right or justice, also in Magna Carta. He's having justice denied and delayed, and that is immediate, harm to him. It's an immediate, harm to his person. And people are petitioning about it. So that Assange, as soon as I submit that Assange petition, really, Parliament actually has the right to read that out, or should do, based on the criteria of it and what it's about, without even it mattering, how many signatures are on it or not. In fact, I've only got 1 or 2 signatures on it. Actually, I've had 5 actually. It got submitted, but I've got a feeling they're going to reject it just to be awkward. So therefore, I'm going to complain to them. About them to the Judicial Conduct Investigations Office, because I believe the office has jurisdiction over the Petitions Committee chairman, and I don't think that they've got a right to reject it, because Assange is an existing case, so the subject to matter is already registered with government. It's not an illegitimate matter. It's not like it's something officially recognised by government that is being dealt with by government. So how can it be rejected? We're seeking resolution from it. So that's how you say. It's like, it's a one-liner. We're seeking resolution from it. For him, and we just slam the signatures. Get signatures on there, and really, the House of Commons should, do something about getting him out of there while we're collecting the signatures, really. It's a high-profile case, and there's, it's got a lot of people turning up outside the courts, so there's that as well. I don't have any doubts about the immunity because, that basis in the Justices of the Peace Act, why would it be in the Justices of the Peace Act if it's to do with statutory instruments that are made by people in government? Well, you can make orders using statutory instruments, and, but also, orders can be similar or the same as statutory instruments, like for a road traffic regulation order and so forth. So surely if you're pursuing a resolution to either the House of Parliament, then, it's just like appealing to a Crown Court from a Magistrates Court, but you're appealing to Parliament. And they don't want to acknowledge that. The magistrates don't want to acknowledge that. They only want to acknowledge, Crown Court or whatever, but, they won't, for some reason, the House of Commons Petitions website, I don't know why, they don't, but it's legitimately, it's due process of law. It figures in, the House of Commons figures in, petitions figures into the justice system and the legal due process of law. That's basically what we're proving and what we've proved. It's part of the judicial system. And they try to say that it's not when it is, and you can't petition about criminal cases or whatever when you can, and so forth, or you haven't got immunity when you have, or clearly you have at least for things in the Town and Country Planning Act, notices, signs, things like that, placing them, removing them, all things in and around there, models. But when we're getting people are getting prosecuted and charged now, it's always criminal damage. But people aren't even acknowledging that Town and Country Planning Act even exists, like the Director of Public Prosecutions. Even when someone clearly he was under the Act, it was defacement, whether you've got permission or not, whether you've got express and dim consent or not. It's not criminal damage, is it, when it's defined in great detail of what it is? So why pick up a banana and say that it's a grapes? Why pick a banana up and say this is grapes? Why get a woman who's painting a political sign on a wall and say it's criminal damage when two full entire acts of law describe in great detail that this is defacement and it's classified and there's processes and fines and so forth, which she's exempted from? Why put it through under a criminal damage, which is, it's not criminal damage. It's clearly explained, defined, described, and the word defined is significant, defined. It's explained, it's described, it's defined, it's identified, it's worded in great detail, which the Criminal Damage Act doesn't, the Criminal Damage Act doesn't even go anywhere near explaining or defining what damage is or isn't. They like to let the courts decide what isn't damage and argue over it. But just a minute, there's an act here that says that at least what this lady's doing clearly is described, explained, and outlined in great detail in this act of law, because that's what she's doing, So this is where we're at with it. Whichever way you look at it, we've got severe, extensive abuses of process all around the country. We've got severe, extensive perversions of the course of justice, whether that's from the Crown Prosecution Service, the police, the chief police officers, and there is some argument over what is and is not acceptable for petitions, but they're not even entertaining that under rights. They're not even recognising that people have got rights or using rights, and they're not even arguing the boundaries of the rights based on description and explanation. A lot of these cases are just going in Gail Bradbrook, why did they do these things and so forth, and then juries deciding just purely based on nothing, when half of it is quite, firstly, they're not saying, oh, by the way, we're using petitioning rights, and secondly, what I'm doing falls within that due to this criteria or not. They're not even touching on that or entertaining it, which is the most concerning thing out of all of it. Anyway, so this petition research is actually really valid and useful now. Actually, I really need to get this Committee for Motions of Griefs and Petitions looked at. So this Committee of Motions of Griefs and Petitions is actually very significant. I've just learned from these research groups who have been transcribing and ordering and compiling a easily accessible, user-friendly library of all these different petitions from history and into sections of quarter sessions, London, House of Lords, Parliament, Privy Council, and so forth, which is what we want, exactly what we wanted exactly what we needed and want to look at. They're saying that there aren't any for the House of Commons hardly. Well, what happened to them? Where are they all? Apparently if they've got ones for the Privy Council and they've got a lot for the House of Lords, you'd have thought those ones would have been the ones that were missing, and not the House of Commons ones. Well, so for the House of Commons, it turns out we want to be looking at this Committee of Motions of Griefs and Petitions. Committee for Motions of Griefs and Petitions. That is apparently the committee that was dealing with it all. So what happened to all those petitions? If all the others are still on record, why did that committee get rid of them all, throw them away, or scrap them? Were a lot of them addressed to MPs in person, the Member of Parliament, and did they have them and just voice them or whatever, or did they not get into the committee? They're saying that they've got some on record because some were published in the newspapers, some were published in the press, some were elsewhere recorded or documented. But so this Committee of Motions and Griefs of Petitions is quite interesting, and we need to learn about this actually as part of this. It only lasted till 1974, which is actually before Barry Shearman became an MP in 1979. But it was all the way from 1571. I think there were other committees as well, and then some of them were just read out in the House of Commons. But remember that they only had Parliament for, in the 1640s until the Long Parliament. They only had periodic parliaments in every so many years, so it wasn't a very consistent thing, the House of Commons. That's why they wouldn't have had that many petitions to the House of Commons prior to John Pym, because it wasn't permanent, was it? They only called a parliament, and if at the exact time they called the parliament, there might not have been people petitioning, or the whole point in them calling the parliament was to have a representative, a member of parliament, to represent them personally. So they didn't have to do petitions to the Privy Council, to the King, to the House of Lords, or through the other courts and so forth. That was the point of calling a parliament. So they went to see their local MP in the surgery, and then he is meant to address their concerns in the parliament for them. That's the point. And obviously they only had it periodically, so it wasn't until after the 1640s when they got a permanent parliament in place, so it had a permanence. I think that's actually a bad thing, to be honest, because too many cooks spoil the broth. But so there were other committees as well. I think just leading up into the Civil War, they had that painted chamber, and there were some other committees that they had here in petitions when they were doing certain investigations and looking at certain behaviour of judges and magistrates and so forth, which I think is basically something like the Judicial Conduct Investigations Office, but it was based in Parliament and committee that dealt with it, not in the Royal Courts of Justice. So 1669 resolution of the House of Commons. Yeah, I've done that. I've looked at that. And then 1840, 1842, and then a little bit after, the standing orders presentation of petitions, which I think all those standing orders have been replaced now by new ones. So we want to find out about this Committee of Motions and Griefs and so forth. And if they haven't really got that many petitions left from the House of Commons, that's the evidence that we won't have. But we'll be able to look at other cases that are brought to the Privy Council or to the House of Lords or other. I'm wanting to find other people who've done actual investigations, a petition of investigation. But then again, they didn't have a police force, did they? So, in a way, really, they were kind of, a lot of these petitions really are self-policing, someone owes me some money, or I'd been mistreated by this gentleman. In a way, I'm scratching my head now, and I'm just kind of thinking, well, if you haven't got a police force, what they did is, if anyone done anything wrong against the state, the sheriff or, whoever sent, someone out to arrest a person and bring them before a court or whatever. But what about general policing of law, citizen to citizen, right? Well, this is the thing. I think these petitions are the cases. I think we were bringing them. I think they are a bundle and muddle of, this person took my things, well, at what point is it a civil dispute or a criminal? Well, depends on if they broke a law or not. But if they did break a law, then if you can't write, then surely you get someone who can write to write into a magistrate's court or whatever, and then they send someone to get them. I think, therefore, I'm kind of thinking that it's almost kind of like what we're looking at really is a kind of splash of civil and criminal disputes that we're bringing with your witnesses signed, or your whoever, your scribe who's writing it because you don't know how to read and write, and then the magistrate's court, whatever. So obviously, but that's that. If someone has done it, because otherwise, what's the sheriff walking around doing if someone broke a law and this or that? But it's almost kind of, I'm starting to think that it kind of is sort of, some of these petitions are like an affidavit, aren't they? An affidavit. Some of these petitions, well, some of them are civil claims to either the magistrates' courts, the quarter sessions, or to the king, or King's Bench, police side and crown side. But some of them are affidavit over criminal matter. And I think that's the thing. You see, once you're starting talking about petitioning the High Court or the King or the Privy Council, you see, you've got civil and criminal matters, in county court and, magistrates' court, and then you've got assizes. But once you get up, when you're raising it up a level, criminal and civil matters merge together and are both dealt with, like in the Royal Courts of Justice. This is why the Inquiries Act can refer, if there's any civil or criminal matters that arise that need dealing with by a court in the Inquiries Act 2005, then they're referred to the High Court, which can criminal or civil, and in a way, really, that's what the Petitions Committee really sort of should be doing. But you're asking for a resolution from the House of Commons, which can actually get criminal matters put through, should it need to, as Richard Tice has said. They can be put through Parliament. But if you're bringing you're allowed. The thing is, you are allowed to bring the case to the House of Commons, because you can petition for an inquiry in a matter that is over matters that can contain civil and criminal matter, both aspects that are of national concern. The thing is, you're wanting the government to deal with it because it's an important matter, and why should you have to bring a private case? Well, in a way, it kind of is a private case, but, you're not going and paying £10,000 for a lawyer to go to the High Court, to take the police, to actions against the police. The petitions to House of Commons for a resolution, if you just wanted to collect signatures on it and raise awareness of it, that is a legal due process, which is protected, particularly if you're investigating it. It's that's what you're doing. You're not going. It's like with Stonehenge Tunnel. Stonehenge Tunnel. They're opposing the government on it, and they collected 200,000 signatures, and really they should have just had a referendum in Wiltshire, and then if the government didn't like the outcome of it, it could have had a national referendum. the referendum in Wiltshire only costs, 50, 60,000 pound or less than. The problem is they're challenging the government through the courts where a judge is going to hear it and they might not win, but based on legal technical arguments. And they're paying 60 grand. We're having to raise 60,000 pound out of donations when they've already given enough signatures in to have the right to have it go to the vote by the people, which doesn't have to be based on legal technical arguments, which is purely on the opinion of the peers, and is cheaper than that legal case. But they've had to go out of their way to get all their signatures, which has put a lot of time and money into collecting the signatures, and then they're not going to use those signatures to allow them to have the vote based on pure opinion. So you've gone out of your way to collect 200,000 signatures, which is a fortune to anyone in voter power. Then, to insult to that injury, which that should afford to buy you the local referendum, which will be judged on pure opinion, then they want to go get us to raise £60,000 to pay a lawyer for profit to legal argue on technical arguments, which we might not win. After collecting the in excess of 5% equal to Wiltshire electorate to do it on the vote, which is already paid for by the taxpayer. It's insane that all because it's like Drakeford. It's my way or the highway. It's Drakeford's my way or the highway. Either it's Drakeford's way or no way is going. And this is where we are with the government of England, with men in hard hats with yellow jackets who want to dig Stonehenge tunnels, executives in care, Balfour Beat Me, handshakes, Boris Johnson walking around with a hard hat on. Who are these agencies? Architects designing our town centre and cultural heart, which they give us a consultation on that they're not even going to abide by. Effectively, we are now owned by contractors, bulldozers. We're owned by cement mixing, bulldozing, tunnel digging, hard hat wearing executives, like Simon Kernaghan in, Highways England, these flamboyant tie wearing executives from companies that, the Prime Minister's got shares in, and they name them after people like Keir Starmer, the leader of Labour, who was the leader of the Crown Prosecution Service, and they call it care. And that's meant to be poetic, but we're not, it's poetic to someone, but to who? We're actually, the country is being run by Bob the Builder. And Bob the Builder, can we fix it? Yes, we can. Well, we're going to, there's nothing wrong with it. It doesn't need fixing. Well, there's no money in that, is there? Bob the Builder likes new technologies and he likes new fashions and styles, particularly when, otherwise there's no money to be made out of everyone, We've actually been hijacked by builders, by corporate builders. And the councillors and the governments are meant to be justices of the peace for commission, but there is no peace. There is only noise. There is only destruction. There is only Wreck-It Ralph. There is only heartbreak, trees being ripped out, traffic noise increase. The peace is being broken and there's no justice. And then in order to mask that, in order to ignore these community groups who are stamping their feet and collecting signatures and banging on the council doors or whatever they're doing, in order to undermine all of that, so it's nothing, it's a flick, it's a flinch, that's not a break of the peace. Instead, we've got immigration pouring in, crime level going through the roof, and instead the police chief's shouting, that's not breaking the peace, this is breaking the peace, stab, crash, bang, wallop, crash, motorway accident, stabbings, bangs, all these things. That's breaking the peace, Meanwhile, there's resentment rising out of destruction by these, dozers, these Bob the Builders, these Bono the Builder with his, apartment blocks, with his bulldozer sunglasses, Bono the Builder, now knighted, apparently, according to Jimmy Dore. Bono the Builder, can we fix it? Yes, we can. This is the thing. Meanwhile, the most people are distracted with this whole, this entire Ant and Dec, I'm a Celebrity, Get Me Out of Here, GB News, Channel 4, Let Me Entertain You, all this TV distraction. Let's get to the O2 Arena. So, while the things that people are upset about and care about are they're even getting people to self-harm. I don't know how they're getting people who've got beautiful shops or beautiful houses, not even expensive ones, beautiful working class houses, cottages, streets. People don't like their area anymore. And then I don't know what happens, but we're all self-harming our areas now, and then people don't want to talk to each other, and then people are blocking each other online. It's an absolute, complete, total nightmare. Something we need to stop. Something needs to be done. And we have rights to. The final point is, we've got rights to seek resolution from Parliament, and we're being denied that right in many instances. They should be expanding the committee to look into these matters and deal with them, and letting us collect signatures to override councils that are, they're disregarding they're doing consultations, but they've managed to somehow bluff consultations into not having any value to them. It's almost like, and everyone, it's almost like collecting money from people and saying that it's just plastic, but it really is. It's almost like £50 notes. This is not, people would accept £50 notes. We don't accept public consultations. Well, that's funny, because we'll have a local referendum instead, and then seeing the likely turnout is going to be the same as a consultation. We already know what the results are going to be. Probably not in your favour. That's why you don't want us to have the local referendum.